During a pretrial deposition, a question and answer session under oath in a medical malpractice case, is it ever acceptable for me to tell the doctor who I am questioning, "Doctor, you didn't answer my question. Could you please answer my question?" Is that ever possible? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, it is entirely possible. Let me tell you why and how. In New York, in a medical malpractice case, during the course of the lawsuit, I will have an opportunity to question the doctor or the doctors whom you have sued. During this question and answer session, which in pre-COVID times would take place in the defense lawyer's office, the doctor's attorney's office. Nowadays, it typically takes place on a Zoom video call. The doctor is on the call, the doctor's attorney is on the call, I am on the call, and any other attorneys who are part of the case will also be on the call. There will also be a court stenographer on the call to record all of the questions that I am asking and all of the answers that the doctor gives. The answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying in court, at trial, in front of a judge, and in front of a jury. Now, many people think that because this is an informal setting, whether it's the attorney's office or on a Zoom video call, that the answers don't matter. That's not the case. The answers do in fact matter. They matter so much that it's critically important that I get a true answer to my questions. There are instances where I will ask the doctor a question, which really just calls for yes or no answer. And instead of giving me a yes or no answer, the doctor gives me a long-winded explanation about what he did and why. Is it ever appropriate for me to stop the doctor, either in mid-sentence or after he's done with his answer, and say, "Doctor, I'm sorry, but that didn't answer my question. Let me ask it again." Is that ever appropriate? The answer is, yes, it is. Now, why? It's appropriate because I'm the one asking questions. I need to know information from the doctor about what he did and why. I need to understand his knowledge of the medicine. I need to understand whether the doctor is familiar with the standard of care in this particular scenario. Many times the doctors don't want to give a straight answer because they know if they answer yes or no to a particular question, it's going to lead them down the path of something that they don't want to go to, which might just show that they are liable and responsible for my client's injuries. In that instance, they will often, instead of trying to answer my question directly, instead try and give a long-winded answer to explain away their actions, to explain away what they were doing and why. When that happens, I may turn around to the doctor and say, "Doctor, thank you for that answer, but that's not what I asked you. Let me ask the question again." And now I will ask the question again. Now, there are some instances where the doctor still tries to give me a long-winded explanation without giving me a direct answer. And I don't want to fight with the doctor. I don't want to argue with him. I'll say again, "Doctor, that was not the question that I asked. Let's try this again." And I will repeat it. And now sometimes the defense attorney will pipe in and say, "Counselor, my client has answered the question. Move on." Can I do that again? Can I ask the doctor to give me a real answer to my question? The answer is yes, I can. What if the doctor still won't answer my question directly? You know what I'll do? I'll put that question to the side for the moment, and now I'll proceed on to another topic. An hour or two later, I'm going to come right back to this question or to a variation of the question. Why? Because the doctor still has not answered this question. So although I've now moved on to other topics and I've gotten other answers from the doctor, I will usually come back to it. I'll circle back, and now I'll bring up this topic again to see if the doctor's going to give me a real answer. In that instance, the defense attorney may object and say, "Counselor, we already answered these questions. We already covered this." And I will say, "No, actually we didn't. The doctor did not respond to my question." And the defense attorney will often say, "Just because you don't like the doctor's answer doesn't mean you could ask it 25 times. It doesn't matter whether I like the answer or not. All I want is an answer to my question, and then I'll move on." Once he gives me an answer, fine, now I'll move on to a different topic. And we go from there. So why do I share this quick information with you? I share it with you to help you understand how these types of cases work in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.